Good morning, everyone. Welcome to our webinar. I'm just going to give everyone a couple of minutes to start the logging in process. So quite a few of us joining the call this morning, so it may take a minute or two to get everyone logged in, but we'll start promptly at 10 o'clock. Just wait one more minute for people are still joining. Okay, it's coming up to 10 o'clock, so just to see, I've got still a couple of people still to join, but let's get going. Okay, let's give it a go. So good morning and welcome. This is our webinar, Flexible Working Requests, Getting to Grips with the New Rules. My name is Lucy Atherton and I am a solicitor with Make UK. A couple of housekeeping points. I'm sure you're familiar with these by now, but we are recording the webinar. You will get sent a recording automatically. I think it comes via Eventbrite after the event. It should be later on this afternoon, but you will get an automatic copy of the recording sent to you. We've got a Q&A box at the bottom, normal Zoom functionality. If you have any questions, please do pop them in the Q&A box. We've got a team in the background who are answering questions throughout the morning on the webinar. So hopefully we'll get through them during the course of the webinar. If we don't, we do have your registration email details. So if you have a question that hasn't been answered, either by the speakers or directly via the Q&A box, we will try to get an answer to you out at you very soon. But don't please use the raise hand function because there's too many of us on the call. We won't be able to monitor that. But any questions, please pop them in the Q&A and hopefully we'll be able to deal with them throughout the course of the webinar. So I know some of you on the call may not be that familiar with who Make UK is. So this slide really is just designed to show you a little bit about who we are. We provide access to services covering HR and employment law, health, safety and sustainability, learning and development. And as part of our policy and representation work, we're closely involved in government consultation, whether it be on employment law or something like net zero, for example. I think that puts us at the centre of the debate on legislation, guidance and government initiatives, and it really helps us influence policy making. So I guess in short, I would probably say everything we do, from providing business support and training to championing manufacturing, everything we do is designed to help British manufacturing compete, innovate and grow. So my part of the business is that blob at 4 o'clock on the clock face that you see, the blue blob, HR and employment law. We are part of the Make UK family and we offer employment law advice, training and development and HR consultancy. The next slide is a bit busy, but this is about the HR and employment law team. And it's an infographic that rather shows you the kind of stuff we get up to. The first point to note is really that the HR employment law team is a team of about 60 lawyers and barristers and HR professionals. So I think that makes us one of the largest teams of employment lawyers and HR professionals in the UK. We answer, as you can see, thousands of employment law queries throughout the course of the year. We offer a full case preparation and representation for clients in the tribunal. And you'll see that last year we had a 95% win rate in the tribunal. We offer comprehensive training, CPD accredited training courses and tailored HR consultancy to help companies manage, protect and develop their team. So I think, in short, we offer balanced, commercially focused HR and employment advice and support. Talking of team, Those joining me on the webinar today are two of my team, my colleagues Sarah Meyer and Beth Unwin. We are part of a team of 5 specialist practice development lawyers who provide technical support to our colleagues to help keep clients on top of developments in employment law. And that's why we're here today. We're going to be looking at developments in flexible working requests. So let's look at the agenda. So during the webinar, we're going to aim to give you a whistle-stop tour of how the statutory rules around flexible working will be changing from the 6th of April onwards. We'll draw out the key changes that will come into force from April. We'll look at what these developments mean for employers and employees in practice. We'll include some thoughts about the updated ACAS Code of Practice, which has recently been revised to reflect the rules. And we will finish up offering some pointers about how you as employers can best prepare for the forthcoming changes and how we as Make UK can help you move forwards. We know there are a lot of people on the webinar this morning, and we're conscious we've only got limited time. We're assuming that the majority of listeners are in HR or those who are typically used to dealing with statutory flexible working requests. So we're going to assume that you're all familiar with the current system, and we're going to focus on the impact of the changes and providing practical pointers from April onwards. This slide is just to briefly set out the legislative framework and the guidance that's available to employers about the statutory flexible working regime. As you're probably aware, the current regime is covered off in sections 80F to 80I of the Employment Rights Act, and you can see the 2 bullet points on the slide there that show you the new Act and the new regulations that were coming into force in April. It is the regulations that make the right to request flexible working a day one right, and it's the Act that makes various other amendments to the flexible working regime, and we'll cover those in more detail shortly. Throughout the webinar, we'll refer to the ACAS Code of Practice, and that's obviously recently been revised. Not so long ago, Make was involved in an ACAS-led working group looking at the revised draft code, and we fed in some comments from our members and clients. So anyone listening who provided us comments, thank you for that. They were passed on to ACAS. So since that working group, ACAS has now published the new updated code, which will come into force from April at the same time as new rules. As before, the code is a statutory one. So this means that, of course, if you fail to follow the code and an employer fails to follow the code, it doesn't itself give rise to a tribunal claim, but tribunals must take it into account when considering claims that they're dealing with about the right to request flexible working. I would recommend a quick read of the code. It's longer than it was before, which is not difficult because the original version was only 14 paragraphs, but it is a good, useful read. It has a non-statutory introduction, which sets out the various benefits of flexible working, and it makes clear really that the employer's default should not be to simply reject an employee's flexible working request. The key emphasis of the new code really is for employers to be open-minded and approach flexible working requests in a constructive way. ACAS has also indicated that it will update its non-statutory guidance, which sits alongside the code, but we haven't seen an advanced copy of that, so I'm not sure what the timing is around that, but we'll keep you posted when we see anything about that non-statutory guidance. Just before we get into the meat of the webinar, I wanted to run through just what we're calling flexible working fundamentals, just some general points about flexible working that will be hopefully useful reminders. Firstly, it's worth keeping in mind that the request for change in employment terms could relate to a change in the employee's hours, the times the employee is required to work, the employee's place of work. And within these 3 simple categories, flexible working can take obviously quite a number of various forms. So the employee might want to home and hybrid working, request for part-time, term time, flexi time, job sharing, compressed hours, lots more other ones I can't think of right now. But the statutory rules apply to all of these types of requests. Secondly, remember that changes to an employee's terms of employment may be temporary or permanent. And on this point, it's really worth reminding you that it's really helpful to agree a trial period for both parties to establish whether the change is going to work or not. We will talk more about trial periods later. Another point to note at this stage is that an employee can make a statutory request for flexible working for any reason. So if a member of your team wants to take a Thursday afternoon off to play golf, they're entitled to make that request. There's no requirement for the employee to state why they're making the request, nor is the right to request flexible working limited to carers or parents. I guess that said, there's nothing in the current law nor in the planned changes that gives an employee the right to work flexibly. The right is the right to request flexible working and to have that request considered in accordance with the statutory regime. One last point on this slide really is it's worth noting that ad hoc flexible working requests may be if you've got an employee's got a medical appointment and wants to adjust their start and finish time on a particular day. That wouldn't be within the statutory scheme. That wouldn't be considered a statutory request. However, there are valid reasons for employers to give these kind of non-statutory requests proper consideration, because you want to ensure that you're complying with the implied duty of mutual trust and confidence between the employee and the employer. So don't disregard non-statutory requests. Do give them proper consideration as well. So we're moving on to the next slide, which I'm going to hand over to Beth, and she will take us through the key changes from the 6th of April 2024. Over to you, Beth.
Thanks, Lucy. So we're looking at what exactly is changing from the 6th of April onwards. Much of the current statutory regime actually will be staying just as it is, but there are key changes we want to draw out up front, and we've bulleted them on this slide. Firstly, the key change you probably heard most about is that the right to request flexible working will become a day one right. This means that from the 6th of April, no service will be required for an employee to make a flexible working request. As a technical point there, it's worth noting that all employees will be able to make a flexible working request when the new rules come into force on the 6th of April, regardless of when they started work. So, for example, someone who started work 13 weeks before that will be able to make a request as soon as the 26-week service requirement is abolished on the 6th of April. So they won't need to wait to get 26 weeks service before making a request. The government's stated hope is that by making the right to request flexible working available from day one, employers will also be more open to offering flexible working opportunities from the start of the recruitment process, and applicants will feel more able to ask for them. Removal of the 26-week eligibility requirement means that in theory, both sides should feel able to discuss if there's scope for flexible working right from the application or interview stage. And the non-statutory forward to the ACAS Code of Practice talks about where possible and appropriate, employers building flexibility into job roles when designing them and advertising them during recruitment, i.e. making clear they're open to discussing flexible working options. We wonder how this will pan out. We think it remains to be seen how open employers will be in practice to having that type of discussion during recruitment. The other changes to the statutory regime and key changes will be more procedural. Firstly, from 6th of April again, employers will be allowed to make 2 statutory requests in any 12-month period rather than the current one. This is to recognise that an employee's requirements for flexible working can change quite quickly, and aims to give employees more flexibility to make requests as needed. Secondly, employers will no longer be required to explain what effect, if any, the requested change would have on the employer and how that effect might be dealt with, something you're probably familiar with under the current regime. Removing this aims to remove barriers to employees asking for flexible working arrangements. It fits with the introduction of the new day one right as well, really, as in practice it would be difficult for someone who has only just started a new job to explain what impact their requested change would have or how it could be mitigated when they don't yet know the business or the working environment in detail. Third procedural change, there will be a reduction to the amount of time employers have to consider a flexible working request. Employers will need to determine a request within 2 months rather than the current 3. This includes any appeal as well, although it will still be possible for both sides to agree an extension to that time frame as it currently is. Just note that in relation to requests that are made in the period running up to the 6th of April, the new legislation makes clear that the changes to the decision period only apply to requests that are submitted on or after 6th of April. So if, for an example, an employee makes flexible working request on the 28th of March, the employer would still have 3 months to deal with it. Perhaps the most significant procedural change is that there'll be a new obligation on employers not to reject a flexible working request without first consulting with the employee. I'm going to talk a bit more later about exactly what consultation would look like, but essentially an employer will not be able to refuse a request before they've discussed it with the employee. And if they don't feel able to agree to the original proposal, the employer will be expected to consider possible alternatives that might work for both sides. Having looked at the key changes, I'm now, over the next few slides, going to go through what the process will look like from April. Some elements of the process won't have changed at all, but it's worth looking at the new and the old together, so we're seeing the full picture, we think. To trigger the statutory procedure, an employee needs to submit a written request, which must meet the various requirements set out in section 80F of the ERA. On this slide, we'll look at what you need to be aware of regarding the request and what you can require of the employee making it. The request must be dated and state the change the employee is requesting to terms and conditions, the date they would like the change to come into effect, and if and when they have made a previous request for flexible working. The employee isn't obliged, as Lucy was saying, to give the reason for the request. As mentioned under the new rules, an employer will be able to make 2 requests in any 12-month period, as opposed to the 1 currently. Although you are, of course, free to consider more than 2 requests if you wish to do so. Employers can choose to be more generous, of course, in the statutory regime. Note that alongside the introduction of the employee's right to make 2 requests per year, is a requirement that they can only have 1 live request for flexible working at any time. A request is considered live unless the employer has made a decision on it, it has been withdrawn, the employer and the employee have mutually agreed an outcome, or the statutory timeframe for the employer to respond to the request has expired. And on that, remember that a request will remain live during any agreed extension to the statutory time frame and during any appeal process. Just a note regarding requests that are made before the 6th of April. The employee I was talking about on the previous slide, making the request on the 28th of March this year, would only be able to make 1 further request between 6th of April this year, 2024, when the rules change, and the 27th of March, 2025, the anniversary of their request. This is because the legislation provides that when determining the number of applications made by an employee during a 12-month period, applications made before the new rules take effect are counted. So when you, as the employer, receive a statutory request for flexible working, it's important you follow the statutory regime closely, unless, of course, you're relaxing certain elements for the benefit of the employee, and that you follow, as Lucy was explaining, the ACAS Code of Practice. To comply with the statutory rules, employers are expected to deal with any application for flexible working in a reasonable manner. You're all quite familiar with the concept of reasonableness in relation to this and other employment rights, of course. The ACAS code gives guidance about what this involves. As mentioned earlier, the code encourages employers to be open-minded and constructive in their approach. Essentially, you shouldn't ever really be rejecting requests outright without some kind of exploration of what can in fact be accommodated. For requests then submitted on or after the 6th of April, you will need to decide the outcome within 2 months of receipt rather than the current 3. So you're only going to have a 2-month window within which to consider the request, discuss it with the employee where that's appropriate, but we think it will be in most cases, and to notify the employee of the outcome. You'll also need to offer and deal with any appeal within this same 2-month window, unless you do specifically agree with the employee to extend the deadline. As I'm sure you'll be aware, you can only, sorry, bear with me, I've just lost. You can only refuse a flexible working request for 1 or more of the 8 reasons set out in the legislation. We'll look at these in a moment, but they actually remain unchanged under the new regime. We're just going to look on this slide at the requirement to consult. This is a really key development. It's important for you to take note of this and adjust your flexible working policies accordingly. All that the legislation says actually about this obligation to consult is that the employer must not refuse an application from the employee unless they have consulted the employee about it. Further guidance, though, is set out in the ACAS code, which we're going to talk about now. The code makes clear that unless you decide to agree to the employee's flexible working request in full, you must first hold a meeting with the employee to consult with them about your decision. This meeting could be a face-to-face meeting, could be in person or remote. The code recommends that you allow employees to be accompanied at the meeting by a colleague or a trade union rep, even though actually the statutory right to be accompanied doesn't technically apply in these circumstances. The code states that the meeting should be held without unreasonable delay. Both employee and employer should have reasonable time to prepare for the discussion, taking into account now we've got the 2-month period for deciding requests. The content of the meeting is going to vary, but essentially the way in which it's conducted should allow for a reasonable discussion and consideration of the request. And it will usually be helpful to discuss things like the potential benefits or other impacts of accepting or rejecting the request, and any practical considerations involved in implementing it. As I mentioned before, there's no statutory requirement for an employee to say why they're making a statutory flexible working request. However, at the meeting, it may help to discuss why the employee wants to change, as long as it's possible to do that without putting pressure on the employee. The advantage of knowing the reason for a request will often help both employer and employee to have a productive discussion about it. From the employer's perspective, it can also help highlight potential discrimination risks. And the code does say that it's important to have all relevant information before a decision is made. If the original request cannot be accepted in full, the code states that the employer and employee should discuss whether it may be possible to secure some of the benefits that the original request sought. So the employer should discuss with the employee, for example, any potential modifications to the original request, or any alternative flexible working options that might be available. In these circumstances, the code also suggests a trial period for determining determining whether a flexible working arrangement will in fact work in practice. Finally, a point that isn't dealt with in the code, but that Make UK would recommend as part of your consideration of the request and consultation with the employee, is undertaking an impact assessment in order to understand the potential impact of the employee's request on your business and to identify possibilities for minimising any potential negative impact. We'd hope that a properly conducted impact assessment will help you make a decision on an employee's request based on business reasons. Also, it should minimise your exposure to subsequent legal claims if you decide you need to refuse an employee's request. Note that if there's a potential disability in play, an alternative form of impact assessment relating to reasonable adjustments may be more appropriate. We do have a sample of that available in our HRL resources, which are free to our members. You'll always want to have a written, I think just back a slide, please, Lucy. Yeah, you should always keep a written record of any meetings so you have an accurate reflection of the discussion that's taken place. And just to end with, there's a sort of technicality here that's been debated a bit. The law really only says that you need to hold a meeting where you might refuse a request. But that said, the code itself suggests it's good practice generally to hold meetings to discuss requests, a valuable opportunity to listen and engage meaningfully with the employee. Therefore, we would say that even if you're intending to accept a request, it's good practice to hold a meeting with the employee. I will in a moment anyway talk about the meeting that the code recommends when communicating the acceptance where you've decided to accept a request. And now we can go to the next slide. As we've said, nothing within the current law or in the plan changes gives employees a right to work flexibly. The right remains simply for employees to make a flexible working request and have that request considered in accordance with the statutory regime and the code. On the slide here, we've listed the 8 statutory grounds of refusal, and they will all be staying as they are, and I won't read them out now, but you'll remember there's a wide range of reasons an employer might refuse a request. Things like the burden of additional costs, impact on meeting customer demand, and negative impact on performance are usually quite key ones. The breadth of issues covered shows that you have substantial scope still for refusing an employee's request. But remember, you must base your decision on the correct facts. Whilst an employment tribunal isn't entitled to assess the reasonableness of your decision to reject a request, one of the specified business reasons, it is entitled to look at any of the grounds which you assert were the reason for rejection to see whether it was factually correct for you to rely on them. Where possible, we think you should provide the employee with further information about why you cannot accommodate a request if that's the case. Don't just provide the statutory reason for refusing. And keep in mind too that even though you are lawfully entitled to say no to a request for one of the reasons shown on the slide, you may still find yourself facing other claims if you decide to refuse a request, things like discrimination claims, which we're going to talk a bit more about later. Again, another reason why it's sensible to provide further information about and document your reason for any refusal of a request. We will look now at your decision, what you need to communicate about that when you've made it, and what other steps you may need to take following that. If you don't decide to accept an employee's flexible working application, you are, of course, going to need to communicate that decision to the employee. As I was saying before, the ACAS code actually recommends offering the employee an opportunity for a discussion, even when you've accepted the request. They say to clarify any further information that may be helpful in implementing the agreed arrangement. So, for example, if a temporary change is being agreed, you could use that meeting to explain what will happen to the employee's arrangements and terms and conditions at the end of that period. And this should also, of course, be documented. If you agree to a permanent contractual change, you'll need to document the change clearly in writing to meet the requirements for Section 1 statement under the Employment Rights Act. And note that employees should be provided with written notification of that change within 1 month. You could do this by way of letter to the employee, confirming that their request has been accepted, and setting out details of the terms of employment that are changing, and when, and stating that all of their terms of employment remain the same, assuming they do. You may decide to, as we've covered, implement a trial period for a proposed new working arrangement. Before embarking on a trial, you should get the employee's agreement to extend the 2-month time limit for dealing with a statutory request, unless the trial period will unusually be completed within the 2-month decision period. You should also document in writing the arrangements agreed for the trial period. This will include what will happen at the end of the trial period, crucially. You should also reserve the right to require the employee to revert their previous working arrangements if the trial is unsuccessful. If, on the other hand, having had the required consultation with the employee, you ultimately decide to reject an employee's flexible working application, it's important to explain your reasons clearly to the employee in writing. As we've said already, although tribunals aren't entitled to assess the reasonableness of your decision, they can find that the rejection has been made on the basis of incorrect facts. And it could be easier for a tribunal to make that kind of finding, actually, if you haven't explained the basis of your decision. Finally, remember that if you reject a request, the employee should be offered an opportunity to appeal. Your written decision rejecting the request should explain how the employee can appeal and the timeframe for doing so, which should be without reasonable delay. Again, the code recommends that you allow the employee to be accompanied by a colleague or trade union rep, although this isn't technically a statutory requirement. So I think now we are moving on to a polling question.
Yes.
Hand back over to you then, Lucy.
Thank you, Beth. I'm sorry I got a bit trigger happy there with the slides.
That's fine.
I didn't throw you off your game quite as well as I was hoping. So this will challenge my technical skills. Clearly, I'm already struggling with the slides. So how I manage the polling question remains to be seen. You'll see on the slide that we have asked you a polling question. It should be a multiple answer approach. You can, I hope, tick as many as you think are applicable. So how do you think the new rules might affect your approach to flexible working? There are various options. No change. Are you more likely to consider accepting flexible working requests? Do you think that the new rules might kind of push forward in the recruitment process the discussion about flexible working? Perhaps will you put it in a job advert, or you more like to kind of raise it formally at the interview stage, or unclear at this stage? No problem if that's your answer. You still have time to have a further think about it. So I'll give you a couple of moments to complete the poll. And then we will share the results. So just looking at the voting, I think we can probably end the poll now. And let's share the results. I think there's a certain amount of you are still unsure. the majority actually say there's going to be no change in your approach, which is good news. It means that you're, I think, already in a position where you are embracing flexible working requests and giving them the proper constructive consideration that the code is certainly encouraging you to do. So that's interesting. Thank you very much for sharing your thoughts there. We're going to move on now, and Sarah is going to take centre stage, if I can find the slide button. And she's going to look at how you handle competing flexible working requests. Over to you, Sarah.
Thanks very much, Lucy. So it obviously can be difficult for employers to know how they should deal with a high level of statutory requests for flexible working coming from a particular team or section of the workforce. I should say, it's pretty unlikely that you'll actually get two identical flexible working requests at the same time. So when we say in the title of this slide, competing requests, really we mean multiple requests from the same kind of environment within your workplace. But which request should you prioritize if you can't accept them all? For example, should you pick the one that you received first or the one that would take effect first? Such as if an employee makes a request while they're on maternity leave that they'd want to take effect on their return, which actually won't be for quite a number of months. Should you take a first come, first served approach, or should you consider all the relevant factors, such as who has protected characteristics and so on? And this is likely to become a more common dilemma for employers as the number of requests is expected to increase once the right to request becomes a day one right. Unfortunately, ACAS guidance in this area is limited. Now, the old non-statutory guidance used to refer to the employer drawing names from a hat, but that approach has always struck us as quite unappealing. We think employers would like to retain more control over which requests they do and don't say yes to. And also, it may not always be easy to pin down which of the permitted statutory reasons for refusal would apply to requests that you reject on the basis that, oh, they just didn't get pulled out of the hat. And it will be interesting to see whether that old guidance is repeated when ACAS eventually publishes the new non-statutory guidance that it's promised. Clearly, there's not going to be a sort of one-size-fits-all response for how best to deal with competing requests. But hopefully the points that are set out on this slide will give you a feel for the types of issues that you should have in mind. So first off, as Beth explained earlier, the ACAS code really stresses the importance of being open-minded and taking a constructive approach when you're considering flexible working applications. So you should approach each request with fresh eyes, and your default position should not be to say no, even if you're handling more requests than you were before. It's also important to avoid any policy or mentality, whether spoken or unspoken, of only allowing a finite capacity of flexible working requests to be approved. You shouldn't draw a line in the sand, assuming that you've reached a sort of saturation point with flexible working requests. And this is especially the case for roles where home working is an option. Although we appreciate that the situation might be slightly different if you have, for example, a production line that needs a minimum number of employees on shift at the premises at a given time in order to operate safely. You might think that you can't accommodate a new request, but if you are minded to refuse one, it's important to be really sure of why you can't say yes. As a general drafting point, we recommend that you consider reserving the right in your flexible working policy to select between competing requests as you consider best meets the needs of your business at the relevant time. But you should make sure that in practice, you assess each request based on relevant circumstances at the time you receive it. And that might include taking into account the impact of other flexible working arrangements that you've previously agreed. And given your obligation is to deal with requests in a reasonable manner, it can be useful to have a conversation with people who have already got flexible working arrangements to see whether they might be able to help towards accommodating new requests. For example, could they adjust their own arrangements in any way to help you achieve a compromise? Of course, if flexible working arrangements are already written into their contract, they won't be obliged to change their terms, but generally speaking, it doesn't hurt to ask the question. It can be useful to demonstrate that you've had an open discussion between people who are making simultaneous requests, although please do keep in mind that this approach may raise confidentiality issues and its appropriateness will depend on the individual circumstances. but your general aim should be to try to accommodate as many people as possible and show that you handle each new request in a reasonable way. Discrimination risks will no doubt play a part in your decision-making. It's important that you consider each situation on its facts and avoid imposing blanket policies. So just as you won't always automatically be able to approve caring requests without due consideration, you shouldn't always say no to requests where you think the reason, if you know it, is more frivolous, like those requests that Lucy mentioned for an afternoon off each week for a game of golf. Trial periods, we've touched on before, they are really something that's worth thinking about. If you decide to implement a requested flexible working arrangement for a trial period, and it's clear that the team's performance is actually suffering as a result of the new arrangement, then yes, it may be awkward to have the conversation, but you can at least explain to the employee why the change they've requested isn't working. And at least you can say that you tried to be accommodating, and you'll be better placed to give clear reasons as to why the arrangement doesn't work. So having considered all of that, I think it's pretty clear that handling competing requests won't always be easy. If in doubt, do seek legal advice on your particular situation to help limit the risk of legal claims. Speaking of legal claims, this slide, as you can see, is all about possible tribunal claims. Now, because you are likely to face more flexible working requests from April onwards, once the right becomes a day one right, so unfortunately it follows that you may find yourself at risk of more tribunal claims. For the sake of completeness, we thought we'd highlight briefly the possible claims that an employee could bring, but we won't go into them in too much detail because actually the claims themselves aren't changing with the new regime. So the types of claims are highlighted on the slide. First off, an employee may claim that you've breached the flexible working legislation. For example, you failed to deal with the application in a reasonable manner. You failed to notify the employee of your decision within the decision period. You rejected their application for a reason that doesn't fall within the permitted reasons for refusal, or you based your decision on incorrect facts. It's also possible that an employee could bring an unfair dismissal or a detriment claim if you dismiss them or subject them to a detriment because they've made a flexible working application. And another possibility is that they might claim that you've breached the implied term of mutual trust and confidence and resign, claiming constructive dismissal. And that could be based on the fact that you've refused their request or just the way in which you handled their application. It's also particularly important to be alive to discrimination issues, as the risk of discrimination claims often does go hand in hand with dealing with flexible working applications. Any of the 9 protected characteristics under the Equality Act could form the basis for a discrimination claim here, but in our experience, the characteristics on which most discrimination claims in relation to flexible working arise are sex, religion or belief, and disability. And it's worth pointing out that the ACAS code specifically notes that if an employee seeks a reasonable adjustment for a disability via a request for flexible working, you must consider this in line with your legal obligations under the Equality Act. If you are contemplating saying no to a request, you should remember that you have to consider more than just whether the rejection could reasonably fall within one of the statutory grounds for refusal. The more important and usually more costly question is whether the rejection could put a particular group at a disadvantage, and if so, whether the disadvantage can be objectively justified. The common example is you've got an employee who makes a request to work flexibly on their return from maternity leave. A rejection of the request could amount to indirect sex discrimination. And this is because it's generally acknowledged that a greater proportion of women in the workforce than men tend to have the main parental caring responsibility. And it's therefore more likely that a refusal to allow part-time working or job sharing or other flexible arrangements would have a greater impact on women than on men. A refusal may therefore amount to an act of indirect discrimination unless it can be objectively justified as a proportionate means of achieving a legitimate aim. Now, the risk of these possible claims highlight the importance of undertaking a proper impact assessment and also properly consulting with an employee before deciding on the outcome of their flexible working application. So, what should HR be doing to prepare for the forthcoming changes? And first of all, you do need to make sure that others within your organisation are up to speed on the changes, just like you will be after this webinar. In particular, line managers and anyone in HR who handle flexible working requests. It's important that those dealing with requests are properly trained. And this includes things like your line managers knowing how to deal with the situation where it won't be possible to make a final decision within the 2-month decision period, meaning that an extension to the deadline would need to be agreed with the employee. Next, of course, you'll need to review your HR policies, in particular, your flexible working policy and any home and hybrid working policy that you may have, to ensure that they comply with the new rules and the updated ACAS code. It's particularly important that your policy expresses your willingness to discuss any alternative if the employee's request can't be accommodated. In the past, some employers have tended to take a bit of a binary sort of yes or no approach to requests without really considering sort of other possibilities. And these changes to the law are aimed at reducing that sort of rigid thinking. You need to have written procedures in place to ensure that a request is considered promptly and in a reasonable manner, and that the employee is notified of the outcome within the statutory decision period. For example, have a good look at any internal procedures you've got, any step-by-step guides that you may have for managers and HR, how-to guides and so on, to see whether any changes need to be made to those. Make UK can provide you with a pack of documents, including a policy, drafting guidance, and how-to documents. If you're a Make UK subscriber, these are available to download in the HRL member resources area of our website. If you're not a Make UK subscriber, you can purchase the document pack and details will be provided at the end of the webinar. So when reviewing your policies and delivering your training, you'll need to decide what approach best suits your organisation. Some employers may decide to just make the bare minimum changes that are necessary to reflect the updated legislative process and leave it at that. On the other hand, if your organisation is more able to accommodate flexible working, you could see this as a useful opportunity to update your practices more fully and to encourage a more positive approach to flexible working overall. And there is a strong business case for reviewing your flexible working stance. For example, doing so can significantly help with talent acquisition and retention and general EDI. When embedded effectively, flexible working can contribute to better work-life balance and increased autonomy for employees, which can boost workforce well-being. And some employers are also able to leverage flexible working to reduce cost, particularly where hybrid working or remote working is coupled with hot desking, which can reduce the amount of office space needed. And given that there are various other pieces of family-friendly legislation also coming into force in April, such as carers' leave and changes to the rules on statutory paternity leave, you may be of the view that it's a good time now to take stock and refresh all of your family-related policies in one go. So a few final thoughts on this slide. These are really some key takeaway messages from us today. It first of all goes without saying that you need to follow the new statutory rules, and to help with that, make sure that your policies and training reflect the new requirements. If you receive a flexible working request, it's important to make clear to the employee that you're taking it seriously, keep an open mind and be constructive in your approach. Show that you're willing to engage in discussions about alternatives where needed, and try to agree to the request if you can. As mentioned, carrying out an impact assessment before deciding the outcome of a flexible working request can help you to understand the potential impact of the request on your business and to consider alternative options where needed. Remember also that one of the most significant changes from April onwards is the need for an employer to consult with the employee before rejecting a flexible working request. If you decide to reject a request, it's important to explain your reasoning clearly and document those reasons in writing. And finally, do keep in mind the potential value of trial periods, which can be helpful for both sides to assess the practical impact of the employee's request. So finishing off the session, we just wanted to give you a bit of info about how we can help you with your flexible working compliance. Make UK has prepared a pack of essential flexible working template documents to meet the requirements of the new regime. And the pack includes the documents that are listed on the slide, but key ones are policy, some drafting guidance and how-to guide for managers, and of course that impact assessment form. Make UK subscribers, as I've said, are entitled to these documents free of charge. They're available in the HRL resources section of the website. And if you are a subscriber, you can also speak to your regular advisor for further guidance on flexible working. If you're not a Make UK subscriber, you can purchase these documents online. There's a URL there on the slide. It's the third of the green bullet points at the bottom. Or if you don't want to purchase online, you can email enquiries@makeuk.org for information on how to purchase them and for further support. Also, as I just mentioned, there is a raft of other family-friendly legislation coming into force soon as well. And again, template documentation on this is available on our website for subscribers or to purchase for non-subscribers. For that, please do email inquiries@makeuk.org. If you would like to hear more from us on upcoming developments in employment law, please do join us at our spring employment law updates, which begin in the next week or so. We're holding face-to-face seminars at various regional locations and also a webinar for people who would prefer to attend remotely. To book a place, please visit our website. You will find the details there. Our consultants and trainers are all experts in their field, and they're experienced in providing day-to-day and specialist advice and consultancy to companies of all sizes. So if you'd like to speak to us about any of your business needs, please do get in touch. This slide is just to give you a bit of a flavour for some of the topics that we've been updating our subscribers on. All of these articles listed on the right are available in the news section of our website. That is available to everybody, whether you're a subscriber or not. And the link on the left will take you to the main news landing page. And finally, on this slide, you can see just a few of our upcoming events. The employment law update that I mentioned a moment ago is there at the top. And a couple of briefings on environment and health and safety issues. And again, all details can be found on our website if you'd like to register. So thank you very much for joining us this morning. There's nothing really left for me to say other than that, and to thank also Lucy and Beth. I hope you found the session helpful. You will see a survey popping up on your screen shortly, and we would be very grateful if you could spend a couple of moments filling it in, as we do welcome all your feedback. Thank you.